All right,
Oh, yeah.
we're gonna go back on the record and cause number 2020 CR 11338, State of Texas versus Joseph Sanchez Contreras. Can I have parties announced for the record for the state,
Ryan Bremer and Brittany Sparks.
for the defense?
Christine McDonald, Mitchell Yeager, and Tanya Rivera.
All right, are both parties ready? State,
Yes, Judge.
defense?
Yes, Your Honor.
All right, in defense, outside, well, off the record, there was something that you wanted to place on the record, is that correct?
Yes, Your Honor.
All right, and what would you like to place on the record?
Would you like me to begin with my motion, Judge?
Yes.
Your Honor, at the time the state closed, I did not get up to make a motion for a directed verdict, and since the charge has not gone to the jury, I'd like to do that at this time.
All right, you may proceed.
Thank you. Your Honor, you heard the testimony that came across from these witnesses. There's two important elements that were not proven in this case. The state has not provided any evidence to show that Ms. Alice Sosawiki was placed in fear of imminent bodily injury or death. And Judge, there's been no evidence to show that my client stole anything from that Family
All right,
Dollar.
and Ms. McDonald, you can remain seated.
Forgot.
No problem.
There's been no evidence to show that my client attempted to steal or stole anything from the Family Dollar at 1826 Rigsby Road, Judge. And for those reasons, I am asking you to grant my motion for a directed verdict.
All right, thank you, State.
Yeah, Judge, I'll respond to both of those. In regards to the committing a theft, Judge, we had Ms. Sosawiki who said that he was taking things and putting them in his jacket, that she said stop, that he needed to pay for it, and that he continued on with those things without paying for them. Judge, that's a theft. That's very clearly a theft. It's taking the property of the Family Dollar without payment. That he committed a theft. There's evidence of the theft from Alice's testimony. Regarding the threatening or place in fear, Judge, it is threaten or place in fear of imminent bodily injury. Alice did say she was afraid. She's afraid. She said that's why she called 911. In addition, it is more threatened. She said that he flicked the knife at her. He, whenever she approached him, he held the knife out towards her as she's telling him to put this stuff back. In addition, he makes another threat when they're going out, when she follows him to the door, that he's going to come back and get her. All these things, I think, Judge, can be taken in context while he's holding a knife, while she is attempting to stop him from shoplifting, that he is threatening and placing her in fear of bodily injury or death.
All right, defense's motion will be denied. And my understanding is you wanted to reopen to offer.
Yes, Your Honor. Yesterday I had a version of Officer Fotis's body cam that was redacted, but was not limited to the specific clip that I admitted into evidence and published to the jury, Judge. I've now made a copy of that clip and I've played it for the state. And I would ask to mark it as Defendant's Exhibit 1 and to offer it to the court reporter in case the jury would like to hear that when they're back there, Judge.
All right, any objections to defense exhibit number 1?
None from the state, Judge.
All right, then defense exhibit number 1 will be admitted. And with that being admitted, defense, do you rest? Oh, yes, you may.
Yes, Your Honor. At this time, I rest.
All right, state, do you rest and close?
State resting close, Judge.
All right, defense, do you close?
I close, Your Honor.
All right, is everyone ready to have the jury brought in for closing argument? State,
State's ready, Judge.
defense?
Defense is ready.
All right, let's bring in the jurors.
All right, so the jury.
All right, you keep moving. All right, everyone, please be seated. I hope everyone was able to find parking. So yesterday, both the state and the defense rested and closed their case. What I'm going to read to you is what's called the charge of court. You will be given a copy of that back with you once you go to deliberate. Charge of the court. Members of the jury, the defendant Joseph Contreras stands charged in the indictment with the offense of aggravated robbery alleged to have been committed on or about the 28th day of September 2020 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of robbery if, in the course of committing theft of property as defined below, and with intent to obtain or maintain control of the property, he intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. A person commits the offense of aggravated robbery if the person commits a robbery as defined above and uses or exhibits a deadly weapon. 2, in the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in immediate flight after the attempt or commission of theft. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of property. Appropriation or appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Property means tangible or intangible personal property or documents, including money, that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. 4, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person intentionally obtains or maintains control of property if it is shown beyond a reasonable doubt that it is the person's conscious objective or desire to obtain or maintain control of property. A person intentionally places another in fear if it is shown beyond a reasonable doubt that it is the person's conscious objective or desire to place the other person in fear. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person intentionally threatens another when it is shown beyond a reasonable doubt that the person has the conscious objective or desire to engage in conduct constituting a threat. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person knowingly places another in fear when it is shown beyond a reasonable doubt that the person is aware that his conduct is reasonably certain to cause the other person to be in fear. A person acts knowingly or with knowledge with respect to the nature of his conduct when he is aware of the nature of his conduct. A person knowingly threatens another when it is shown beyond a reasonable doubt that the person is aware that his conduct is reasonably certain to cause the other person to be in fear. A person acts knowingly or with knowledge with respect to the circumstances surrounding his conduct when he is aware that the circumstances exist. 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the 28th day of September 2020 in Bexar County, Texas, the defendant Joseph Contreras, while in the course of committing theft of property and with intent to obtain or maintain control of said property, did intentionally or knowingly threaten or place Alice Oswicki in fear of imminent bodily injury or death, and Joseph Contreras did use or exhibit a deadly weapon, to wit, a knife, that in the manner of its use or intended use was capable of causing death or serious bodily injury, then you will find the defendant guilty of aggravated robbery as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will find the defendant not guilty. In this case, evidence has been introduced to the effect that the defendant may have previously been convicted of offenses other than that for which he is now on trial. In this connection, you are charged that the court permitted this evidence to be introduced for the purpose of aiding you, if it does aid you, in passing on the credibility of the defendant as a witness in his own behalf and the weight to be given his testimony. And you are charged that you may consider such evidence for that purpose and no other. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After you have retired to your jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by signing the same as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, and verdict forms are attached. And State, are you ready to proceed?
We are, Judge.
All right, you may begin.
The amazing part, what I believe is the amazing part of our jury system is that 12 of you guys, 12 people who live in Bexar County, come together and apply the facts of a case that happened in the community where we live and the law, and you decide what conduct is allowable in our community. And in this particular case, down on Rigsby Road, Alice Wiki works at a family dollar. Okay, it's probably not the most glamorous job in the world, but she likes it. She's been there for 15 years. She works there. She's been at this location for several years. And sometimes she has to deal with shoplifters, okay? And that's probably something that's not a fun part of her job. But on the days that we're talking about, not only did she have to deal with a shoplifter who had the audacity to come in there and take stuff that wasn't his, but she had to deal with Joseph Contreras, who now she's approaching a guy who's going to pull out a knife on her for just doing her job. She's there working, and someone comes in to steal and is now pulling a knife and flicking a knife at her, making threats at her, telling her he's going to come back and get her. Now, those are the facts of this case. He's found around the corner with the knife, wearing the clothes that he was in. He doesn't have the candy bars. You know what someone who wants to get away with something does after they leave the scene of a crime? They get rid of it. Now, in this case, you apply that to the law. And the law works in this case too, okay? Now, these are the elements of our crime here, right? And I think in Boydire, I broke it down a little easier for you guys. And I essentially said, look, we have to have a robbery, okay? In the course of committing a theft and with an intent to obtain or maintain property, you threaten or place in fear of imminent bodily injury. And that's exactly what Joseph Contreras did in this case. He's stealing the candy bars. He realizes someone's trying to stop him. He doesn't like that. So the knife comes out. The threats come out his mouth. And that's what makes it aggravated, right? The knife. Everyone knows the implication of what a knife is whenever you're talking to someone and they're threatening you. And the reason it becomes aggravated is because, look, this takes something that is a shoplifting and makes it dangerous, right? Now Alice is suddenly, just for doing her job, looking at a guy who she has no idea what his intentions are with that knife. She doesn't know if he's going to use it against her. She doesn't know if he's going to use it against one of her customers. That knife has just made a already silly situation dangerous, okay? And we believe that on those elements, he's guilty beyond a reasonable doubt to aggravated robbery. That's the law in this case. Now, I want to go over a few things about reasonable doubt. And each one of you were selected based on your answers during voir dire because we believe you can use your logic, your common sense to find a just verdict in this case, okay? You can use your common sense, you can listen to the evidence, you can hear a situation and say, look, I know what happens in this case. Beyond a reasonable doubt applies to the elements, all right? Like I told you when I showed y'all that gun picture, there's gonna be certain things that we don't have answers for. If a camera doesn't catch something, if we don't have a camera, we look at the evidence we have and we decide, does that fit the other evidence? Is it corroborated? And is that beyond a reasonable doubt as to those elements? And in this case, your evidence is going to consist of the testimony from this witness stand, these photos that I showed you at the beginning, and Brenna will have a couple more that will go back with you for various things. You have the video surveillance. Remember of him coming in the store and him coming out the store with Alice following him. You have a knife. I brought the physical knife. And you even have Joseph Contreras' testimony. And all that is evidence that you can use to decide what the appropriate verdict is in this case. Now, police reports will not go back with you. And I know you saw a couple of police officers who referred to the reports. It's a legal reason that neither me nor the defense nor the judge has control of. Those are for them to refresh their memory. Those do not go back with you. But the other stuff is the evidence in this case. And you guys are the exclusive judges as to the credibility of each witness, all right? And I think that the big credibility issue that you guys need to think of is Alice Ozwicki versus Joseph Contreras, because they testified to two very different things. And you can look at the motivations for why they would testify that way, and was it corroborated by the other stuff that came in? Alice Ozwicki works at Family Dollar. She's worked there for 15 years. Is she going to put her job in jeopardy? What incentive does she have to make up this story about this person who she's confronting over shoplifting, who's now pulled a knife out of her? And somehow she's going to guess correctly when Mr. Contreras said he never pulled a knife. He said, I didn't commit a theft at that Family Dollar. I just went in there with my earbuds. I left. I don't know, that video shows me going the wrong way from where I actually went, but I never pulled out a knife, never made a threat. I went to another store to steal an ice cream. I didn't steal there. I went to another store directly after to steal an ice cream. But somehow she knew exactly that he had a knife in his pocket and the color of the knife. If she was going to make this up, she could have said he had a gun, he had a red knife, he had this. The reason that all that is nonsense is because he pulled that knife on her. That's why she knew he had a black knife. That's why that black knife was found on her that you're going to get back there. You can weigh that testimony. You can look at the motivations for either side to say what they're going to say, and you guys know who y'all can give the credibility to. Now, in a second, I'm going to sit down. The defense is going to get up and argue, and then after that, Brittany's going to get up. And what I expect the defense to say is they're going to make a lot of arguments about things that they're going to believe that Joseph Contreras is not guilty. And what I ask each one of you guys to do is, as they're making these arguments, to remember that they must be based on credible evidence that you've heard. Don't go down rabbit trails. This is a case where the defendant is found around the corner with the weapon he used right after he committed a shoplift. Them saying that you need another witness when Alice Ozwicki is corroborated by the way they find him is them trying to distract you from the elements that you guys have to find. The same thing with the surveillance camera. We talked about this in voir dire. Surveillance cameras didn't exist for thousands of years. Just because something happens and it's not on camera does not mean it doesn't happen. I believe that you guys can apply what happened in this case and know that Joseph Contreras pulled out that knife, threatened Alice's wiki, because that's what he did. And you can use the facts and the law in this case to find him guilty and hold him accountable. You can decide that that conduct he showed on that day is not allowable in our community. And that's what I'd ask you to do, is to find him guilty. Thank you.
All right, defense, are you ready to proceed?
Your Honor, just 1 second while this.
Sure, no problem.
May it please the court.
Yes.
Opposing counsel, ladies and gentlemen. Ladies and gentlemen of the jury, sometimes juries hear a case and they know the state just doesn't have it. They just don't have enough evidence to prove that case to you. And I'm sure when you walked in this trial, you expected to get credible evidence. You expected that evidence to be wrapped up in a pretty little bow so you could go back there in that jury room and give a verdict worthy of confidence. But that did not happen here. That did not happen in this trial. And when the state doesn't have that, when they just don't have enough evidence to prove their case beyond a reasonable doubt, it is your job to find my client not guilty. It's your job to acquit my client. Now, before I go into the specific evidence that you heard in this case, I'm going to talk just a little bit about the charge. And I encourage you to read that charge, but it's because it's important. It's the law. It's what you have to follow. Because in that charge, that's where you're going to find all the elements that the state has to prove beyond a reasonable doubt. And that burden never shifts to me or my client. That's the state's job. They had plenty of opportunity to bring things to you. They had plenty of investigators working in their office that could have brought more to you. And those elements can be found under paragraph 5 of the charge. I'm going to read that to you again. The state must prove beyond a reasonable doubt that on or about the 28th day of September 2020 in Bexar County, Texas, the defendant, Joseph Contreras, while in the course of committing theft of property and with intent to obtain or maintain control of said property, did intentionally or knowingly threaten or place Alice Osowicki in fear of imminent bodily injury or death. And Joseph Contreras did use or exhibit a deadly weapon, to wit, a knife, that in the manner of its use or intended use was capable of causing death or serious bodily injury. Now, please remember when you're back there, you can't pick and choose these elements. The state has to prove each of those elements beyond a reasonable doubt. Now let's talk a little bit about beyond a reasonable doubt. Now, as we told you in voir dire, there's no definition, right? There's no definition of beyond a reasonable doubt. There's not a page in this charge that you can point to that definition. But that doesn't mean it's not important. That doesn't mean it's still not the highest burden of all. And you know how you can tell how important it is? Look at this charge. See how many times it says beyond a reasonable doubt in here. It says it over and over because it's important. And not only that, not only is it in the charge, but we talked about this in voir dire. I talked about it. The state talked about it. The judge talked about it. You heard it. You keep hearing it because that's the standard. Now, as I said before, I can't tell you a definition, but I sure can tell you what it's not. It's not, it does not mean that it's probable or more likely than not that someone is guilty. That's over here. It's a standard, that's a standard in civil cases. There might be a situation when you're back there and you think, maybe my client is probably guilty, but you don't believe it beyond a reasonable doubt. And in that situation, you are required to find my client not guilty. And I can tell you what it is more proof of as well. It's more proof than clear and convincing evidence, which is right around here. They have to show you more than clear and convincing evidence that my client is guilty. And they didn't do that. Beyond a reasonable doubt is way over here. It's the standard of proof that you must take when making the most important decisions of your life. It's the standard that you must take when your life is in your hands. Because this is not a civil case, this is a criminal case. This is important. And the prosecutors must prove each of these elements beyond a reasonable doubt to you. Now that I've gone over the charge and reminded you of these things, let's take a look at the evidence and see why the prosecutors failed. They failed to prove their case beyond a reasonable doubt. Now, you've received absolutely no credible evidence that Ms. Alice Osawiki was placed in fear of imminent bodily injury or death. You've received absolutely no credible evidence that my client stole or even attempted to steal any candy or electronics from that store. Now let's begin and go through the witnesses that you heard from. The state's touched on them, but I'm going to tell you more. The first witness you heard from was Alice Osawiki. And I'm going to talk again about fear here. Now she took that stand and she wanted you to believe that she was scared for her life. She's got on that stand and she told you that she was in fear of imminent bodily injury or death. But she wasn't scared that day. She was not scared that day. And you know what? I had to impeach her with her own statement because she continuously denied that. And I played that statement for you and I showed it to you. And it said, and I quote, "Yeah, he threatened me. He said that he was going to come back and F me up like he was looking for my car, but he didn't see it that day." Which I'm not scared of him because they'll tell you that, but they're not going to. And she doesn't stop there. She doesn't stop there because the officer keeps talking to her about that because he knows she hasn't said the right thing. He knows that. And what else does she say? "I've called you before on different things that I'm scared of, but these little situations, I'm kind of used to it because they don't scare me." That's twice that she said that. And even after I played that video, she still sat up there and she continuously denied that she said that. You heard her. You heard her say that, and she still sat up there and lied to you. And when I asked her about that, did you pay attention to her demeanor? She got argumentative. She got upset. And you know, she said she was not talking about my client. She tried to make you believe that it was a general statement, that she didn't mean that. She wasn't talking about my client that day. The officers were there to talk to her about my client that day. She was certainly talking about him when she was talking about her car, but no, the fear part, no, she was not talking about my client. But you heard her, and you're gonna have that video, and you can go back and you can play it. She clearly said him. She was not scared of him. And also, when you're back there watching that video, pay close attention to her demeanor. Look how she's leaning on the building. She's talking casually to the officers. She's not scared. She's not shaking. She's not crying. She's talking about it like you're talking about some normal thing that happens in your day. Now, what else did you get from the stand from Alice Osawiki? Well, let's talk about what she kept from officers. Let's look at some of the things Alice didn't tell the officers. Well, to begin, she didn't tell you the name of the customer that was involved in this altercation. She testified that that person is pretty regular. She sees him pretty frequently. She even testified that she saw him several times after this incident. She could have talked to that customer about presenting himself to the officers. She could have offered that to the police officers. Why didn't she do that? Why is she trying to hide that customer from you? Is it because they're not going to tell you or stay consistent with her version of what happened? Now, something else that she kept from you guys. She mentioned a cashier who said that who she said was also present when this happened. Where is that cashier? Because if the customer can be located, you better bet that cashier can be located. That cashier works with her. She's the manager. She has his number, his name, his schedule. She could have told that detective, he's working on this day, come back because that person can add to this story. Why didn't she do that? Why did she want to hide that from me? Was his story inconsistent with what she had to say? Because that cashier would have been right in the area, right there, where she said she saw my client stealing candies and electronics. Now, don't get me wrong. I know it was kind of tough on her, but I'm not saying Alice is a bad person. I'm sure that her job is tough. I'm sure working at that Family Dollar in that location is hard, and it's probably dangerous at times. But she said on that video that she was not scared of my client. She was not scared of my client. There may be other times involving other customers where she was scared, but she was not scared of my client. Now, how many of those other times dealing with different individuals work their way into this case? How many of those other times, all the frustrations of her job work their way into this case? Because the way she feels about her job, the way she may feel about other customers that she's dealt with, other shoplifters, that should not be a reason why you convict my client. He has nothing to do with that. And you know what? The state compared her testimony to my client's testimony. And I'm going to do the exact same thing for you. Because I can tell you, man, he was cool as a cucumber up there. And he told you that he waited 2 years in custody to tell you his story. He told you that up there. He wanted to tell you. He wanted to take that stand and have you hear the truth. And God, was he honest? My client was honest to a fault. I mean, he admitted to the felony conviction. He admitted that he pled to that. He even admitted that he went down the road to the Dollar General and took a tub of ice cream from that store. He didn't try to hide that from you. He wasn't evasive. He wasn't argumentative. He told you. You know why he told you that? Because my client takes responsibility for his actions. My client takes responsibility for what he does. But don't confuse the situation. We are not here for a shoplifting case at a Dollar General. That is not why we're here. That charge tells you we are here for an aggravated robbery that occurred at 1826 Rigsby Road. That's why you're here. Don't confuse that issue. Now let's look at what came out in his testimony about his interaction with police officers on the day of the incident. Now, the defendant was cooperative. Nothing illegal was found on him when he was searched. And most importantly, nothing from the store was found on my client. There were no candy or electronics found on my client. And the state wants you to believe that he went and he ditched those candies?
Okay, let's consider that scenario. Why keep the knife? I mean, she's being accused of pulling out a black pocket knife. Why not toss that too? It's because it didn't happen. Now, what else did he say? He told you that the only reason he went to the Family Dollar was to check his debit card, and he was run off by Miss Osawiki. And he told you that he did not steal from that store. He told you that he did not threaten her. He did not pull out a knife. And it's your job to assess his credibility, not the state's. It's yours. You compare his testimony to Alice's. You compare their demeanors and see how he sat there. He didn't twitch, he didn't shake, he wasn't evasive. He told you the truth. Now let's move on to the police officers. And you know what? When they were up there and I was crossing them, I might have been a little rude. I might have been a little curt. I might have cut them off at times. And if that rubbed you the wrong way, please don't hold that against my client, because I know I can get a little loud. I can raise my voice, but I gotta tell you, that man right there, he's been my client for 2 years. For the past 2 years, I have been his only voice. I have been his only voice to help him out. And you know what? Sometimes that voice has to get a little loud. But you know what? Today that's going to change as soon as you get back there. Because when y'all get back there, y'all are his voice. I'm going to leave him in your hands. And I sincerely hope that you're going to take that as seriously as I have for the past 2 years. Now, I'm going to get back to the officers. I might seem a little bit like a broken record when I'm talking about them, because I got to tell you, there was a pattern of incompetence on that stand. And I say it that way because the things that I'm going to point out, these are not just mistakes. These are not just mistakes. Because you know what? Officers are human. They make mistakes. But there's a huge difference between making a mistake and just downright not caring. Just downright not bothering to gather evidence. And that's exactly what happened in this case. Now, which officers did you hear from? Let's begin with Officer Thurs. Now, Officer Thurs was a reporting officer in this case. He was the first person on that scene. He was the first person who talked to Alice Osawiki. And he was at that scene for quite a while. He was waiting for the detective to get there. And he's the first person who had, like I said, who had the opportunity to bring you evidence that you could see today. But Officer Thurs didn't bother identifying any witnesses in this case. The only person he talked to that day was a complaining witness, Miss Osawiki. How long was he waiting for that detective? Why didn't he go in the store and talk to people? These are not hard things. These are elementary things. You go into that store, obviously there's more employees working there. Alice testified to that. And you ask them, did you see anything? Can you add anything? Did he do that? He testified that he did not do that. He did another thing. He didn't talk to the employees, but he also didn't bother asking the name of the customer that was involved in this altercation. He didn't ask the name. He didn't ask for more information. He didn't ask for number. Because you know what? You know what his excuse was? Oh, well, that customer left. That customer left before we got there. But just because he left, that doesn't mean he doesn't disappear. He didn't fall off the face of this earth. He could have tried to contact him. He could have gotten more information, but he just didn't bother. Another thing that he had plenty of time to do was review the surveillance video in that store. And you know, when I asked him about that, he got a little upset. But the fact of the matter is, if you're waiting there, if it's your job to try to, gather information on this case, he could have gone to that back office. He could have sat in that chair and tried. He could have tried to get the surveillance video, and if he couldn't do it, okay, but he was wearing a body cam. He could have recorded it, but he didn't bother. And he had plenty of time to do all those things. Now let's move on to Officer Prado. Now, Officer Prado was the arresting officer in this case. He testified that he located my client shortly after this incident. I don't remember the exact time, but it wasn't long. He said it there, it wasn't long. And it wasn't very far either from the store. It was just a few blocks away from the store. And my client wasn't in a vehicle. He wasn't in a vehicle where he could easily get from place to place. He was on foot. He didn't have any bags. He didn't have anything with him to conceal that merchandise. And you know what? They approached my client. He didn't see him coming. He didn't have time to ditch anything. They approached my client, and what did he do? That officer also testified that my client was cooperative. He testified that he didn't resist arrest.
5
He
minutes.
didn't try to run. He testified that my client was searched and nothing was found on him that was supposedly taken from the store. That's another witness telling you that nothing was found on my client. And finally, there's Detective De La Rosa, one of the detectives assigned to this case, who spent a grand total of 10 minutes and 51 seconds following up. 10 minutes and 51 seconds. Is that enough follow-up on an aggravated robbery? No, absolutely not. Now, that detective walked past this aisle to that office in the back. He walked under those surveillance cameras and he didn't bother asking. He didn't bother checking to see if they were in working order. And he mentioned, oh, they might have been dummy cameras. There was nothing up there. No testimony that they were dummy cameras. Alice told you that they were in working order. He just didn't bother to get them. And you know what? He had reports to review. He should have known that nothing was found on my client, that no candy or electronics were found on my client. And if he didn't know, he should have known. And once again, Detective, and let's point out the employees as well. It's not like the employees were offering, hey, we have other camera angles, you should probably stick around because those are working. And you know why they didn't do that? Because it wouldn't match Alice's story. It was not going to show my client stealing anything. And they knew that. Now, Detective De La Rosa also had a second opportunity to speak with Alice Sosoliti and to ask her if any other employees witnessed this incident, like the cashier, who she says was present, like the customer, who nobody bothered looking for or getting a number for. But he didn't do it. And then when I was asking about his report, he mentioned that there were 2 detectives assigned to this case. 2 detectives. And when I was asking him about his report, he even said that in addition to those 2 detectives, there's a sergeant who looks over his report, who looks over his case file, and who can tell him, hey, you did not do enough. We need more here. That sergeant didn't do that. And then after that sergeant, that case, it gets presented to the district attorney's office and they review the case file and they could request from the detectives, they could call them and say, we need more evidence to prove our case beyond a reasonable doubt. And they didn't do that. Not one of these government agents did that. And you know what? And that was not because none of this evidence was available. They just didn't bother. Now, the state talked to you a little bit about the 1 witness rule, and I'm going to quickly do it now because I'm running out of time. But they ask you questions about scenes of crimes and who chooses where those happen, right? And they reminded you that it's not the complaining witness that gets to choose where incidents like this take place. And you know what? Sometimes Sometimes that's true. But this is not a dark alleyway. This is not an abandoned dead-end road where it would be hard for the state to find additional witnesses. This happened at Family Dollar. That is a public place full of customers. And Alice got up there and she told you that it was a busy store. And she told you that it was particularly busy on that day because it was the end of the month. And they didn't bother asking if any of the other customers saw what happened.
1 minute.
Now, is that fair? Is that fair to my client? Because he may have had different experiences than you, and he may be a little rough around the edges, but he is still a member of this community. He is still afforded all of the rights that we talked about in Board Dyer and that you'll read in this charge. I need you to consider all of this when you're back there in the jury room. I need you to look at each element and decide if the state proved that to you beyond a reasonable doubt. The highest burden of all, the burden that you would make the most important decisions of your life. And there may come a time back there where you get tired, but you can't. There may come a time back there where you want to waver, but you can't. You have to continue to vote not guilty. Can I just wrap up?
Yes.
And if you have a longer debate about the elements of this case, consider this. The fact that you're having that long debate is because you have reasonable doubt. So I'm calling upon you now, ladies and gentlemen, to be true to your oath as jurors, to hold the state to their burden and to find my client not guilty. Thank you.
State.
The first thing I want to do is go over something that defense counsel pointed out to you under paragraph 5, which is the elements that we have to prove to beyond a reasonable doubt. And within that paragraph, there's an or. Okay, it's threatened or place Alice in fear of bodily injury. It's not and. We don't have to prove that it was he threatened her and placed her in fear of bodily injury. It's an or. So when you go back there, I want you to remember that. And you heard her say multiple times, and on the video that defense counsel keeps referring to, yes, he threatened me with the knife. The next thing I want to do is go over the consistent arguments that we've heard from defense counsel throughout the entirety of the trial. The first one is that Alice is lying. She wasn't afraid. And just like Ryan asked you all, I want to ask you again, what incentive does she have to get up on the stand and tell you she felt threatened or that this man pulled a knife out on her? Just like Ryan said, she has worked for Family Dollar for 15 years. There's nothing for her to gain. There's no incentive for her to come here, have all of us here and listen to her for it to be a lie. The next thing, just like Ryan said, is her story is corroborated. You've heard two versions of the story. The first one from the victim herself, Alice, and the second version is from the defendant. Alice's story is the only version that matches the evidence that you saw and heard, and it's the only version that makes sense. You heard from the officers who responded, and they told you that at the end of their investigation, they decided and concluded that they had enough evidence to arrest Joseph Contreras for aggravated robbery. Alice told you she deals with thefts all the time. She doesn't always call the police because it's not worth their time to come out there. But she did in this case. You know why? Because she felt threatened. Because Joseph Contreras pulled a knife out on her when he was standing 2 to 3 feet away from her. All she was doing was working her job, doing what a manager is supposed to do, and confronting someone who just stole. Now, he is found with the knife not too far from the location, and Alice's story hasn't changed. This case has been pending for 2 years. She has told the same story for 2 years. Alice isn't lying. And she was afraid. And she did feel threatened when Joseph Contreras pulled the knife out on her from 2 to 3 feet away. The next thing I want to talk about is, well, something happened, but it wasn't an aggravated robbery. And this is the story you get from Joseph Contreras when he took the stand yesterday. He said he went into the Family Dollar, but he only went to check the balance of his ATM card. And then he walked to the back of the store to try to find the ice cream. They didn't have it, so he left. And he didn't steal from that Family Dollar, but he walked down the road to the Dollar General and he sold ice cream from that store. And then when we confronted him with the video, he says, yes, that's him walking in, but no, when he walked out, he went to the right, not to the left. And Ryan asked him, okay, so you went to the left towards Roland Street where you were found. You're saying, but you went to the right. And he agreed. It doesn't make sense. Everything he told you yesterday, was he nice and responsive? Yes. Was it the truth? No. It doesn't make sense. And I want you to remember that. Compare Alice's story and Joseph Contreras' story with all of the evidence that you have seen and heard, and you'll find it doesn't make sense. So yes, things happened, but the thing that happened was an aggravated robbery. The next consistent theme has been, this was a bad investigation. The cops didn't do what they were supposed to do. Are there things that we all, every single one of us, would have liked to have here today that we don't have? Yes. But it's always easier to be the Monday morning quarterback than being the quarterback playing the game. In other words, it's easy for us to sit here today and say, oh yeah, if I was that officer, I would have pulled that video surveillance. I would have talked to that customer. I would have forced that customer to be involved in this investigation. It's easy to say that as we sit here today, but we're not there in the moment. And everything we have, all the evidence we presented to you, that is what was enough for the officers who responded to make the decision and conclude that Joseph Contreras committed aggravated robbery. Now, and Officer De La Rosa, he got on the stand and he told you, yes, I could have done more. Yes, I should have noticed that. And he told you out of his own mouth, I am learning every day. Every case I'm getting better. I learn from that case and I use it on the next one. He's human, just like all of us. But don't punish or blame Alice because you wish SAPD did more, or because you think SAPD didn't do enough. Don't let Joseph Contreras get off scot-free because SAPD didn't do what you think you would have done in that situation. Now, a few other arguments that have been brought up to trial in defense counsel's argument. Officer Prado took the stand and defense counsel asked, is it illegal to carry a pocket knife on you? We all know it's not illegal, but you know what it is? Pulling that knife out on someone and threatening him, that's illegal. They also want to keep talking about this mysterious customer. The customer's not mysterious. Sure, we don't know their name, but you know what? The officer said they were there, but they did not want to be involved. You cannot force someone to be involved in an investigation they don't want to be a part of. That's not Alice's fault. That's not Officer Torres' fault or De La Rosa or anyone who responded to that scene. And again, they keep talking about Joseph Contreras wasn't found with the candy on him, the stolen items on him. The candy is of no value to Joseph Contreras, but he was found with that knife. And you know why? Because that knife is of value to him. He can use that knife again, over and over, to get more candy, get ice cream, whatever he wants. So of course he's going to be found with the knife and not the candy. Now, you might have all been sitting here throughout this trial and saying, why is this important? We are not here because Joseph Contreras stole $30 worth of candy bars. We are here because when the defendant was confronted for stealing those candy bars, he responded by pulling out a knife and threatening Alice with it. And it's up to each and every single one of you as members of the Bear County to tell Joseph Contreras that's not okay. It's not okay to pull out a knife on Alice, that other customer, or anyone, ever. And it's up to each and every single one of you to hold him responsible for his actions, which is why we're asking you to find Joseph Contreras guilty of aggravated robbery.
All right, ladies and gentlemen, you've heard all the evidence and you've heard closing arguments from both sides. Now I'm going to send you back. You now have the court's permission to deliberate, but I'm going to ask that Ms. Villarreal and Mr. Claire, if you guys could stay behind, please. Everyone, please rise.